Good evening. The March 21st, 2023 Board of Adjustment meeting is now in order. The first item of business is approval of the minutes of the February 22nd, 2023 meeting.
Yes, I have one. On page 8, at the bottom of decision of the board section, so just above the motion passed 7-0, the second to last sentence reads, he said, anything that would have been done to the house would require a variance, and in this case, what's being asked for would make it less nonconforming, but it should read, what's being asked for would be less nonconforming.
Okay.
Yep.
Yes. Beth.
And on page 11, which is actually page 16 of our packet, the fourth line from the top, it says which violated the 2025 variance. That should be 2015 variance.
Oh, okay.
Sure.
Any other changes for the first minutes, Mr. Ram?
Yes, thank you, Madam Chair. Page 9, the second paragraph after speaking to the petition, last sentence, it says, Mr. Bardong said there was no street and that the land went into the backyard of the Planet Fitness gym. I would delete Planet, it's actually not a Planet Fitness gym, so I would delete that and just say the neighboring property.
Okay.
And then on page 10, there's the discussion of the board, paragraph beginning, Mr. Rayom, about halfway down it, it says, he said that the structures on lots 140-2 and -4 were two-story ones, and lot 8 was probably not a buildable lot. If we can, add, after the comma, say, and that portions of, and then the lot 8, near the subject property was probably not a buildable lot.
Okay.
That is all. Thank you.
Okay, thank you. If there is nothing else, is there a motion to accept
Make a motion to approve the minutes on February 22nd
with the,
with the changes stated.
thank you. Is there a second?
Second.
Thank you. All in favor?
Aye.
Hi.
Okay. We move on now to the minutes of February 28th, 2023. Are there any amendments, comments? No. If not, is there a motion to accept the minutes as drafted?
Make a motion to approve the minutes as stated in our packet.
Okay,
A second.
thank you. All in favor?
Aye.
Aye.
I'll abstain. I wasn't here.
Before we go any further, I do want to announce that 67 Ridges Court and 635 Sagamore Avenue have decided to postpone their hearings for tonight. Okay, so we will have to actually take, right?
There goes half the room.
Yes, so I need a motion to accept this.
I'll make a
Suspend
motion
the rules
to postpone
We have
item,
to suspend the rules.
We need a motion to suspend the rules so that,
make a motion to suspend the rules.
okay, second?
Second.
Okay, this can be a voice vote, right? Yeah. All in favor?
Aye.
All opposed? No. Okay, is there,
Make a motion per request to postpone item B under old business, the request of 635 Sagamore Development Corp. LLC. And
yes,
Point of order, Madam Chair. Could we just handle these two separately? I am recused on one of them.
we certainly can. Would you
Thank you.
do them one at a
okay,
time?
make the motion to postpone item B under old business, the request of 635 Sagamore Development Corp.
Is there a second?
Second.
Okay. All in favor?
Aye.
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 All opposed? Okay. Second motion, please, for,
Make the motion to postpone item, let's see, item 3A under new business, request rehearing for Jeffrey and Melissa Foy at the property at 67 Ridges Court.
Is there a second to this motion?
Second.
Okay, thank you. Is there discussion?
Madam Chair, I'm just curious for the reason for the applicant's request to postpone.
The number of board members that would be voting is my understanding.
Okay, and that is only 5?
Yes.
Okay. All right, thank you.
Okay.
Just a question, when will it be heard?
I don't know if that was set to a time certain, is it? The next one?
The next meeting would be scheduled, so it would be the April meeting.
Not next.
Not next Wednesday, not next
not
Wednesday, when we
not
have
April.
11, yeah.
Yeah.
The
okay.
next regularly
April.
scheduled meeting.
Okay.
Okay, so all in favor of this postponement, say aye.
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 Aye, okay. Opposed? All right. So, speakers get 15 minutes. If they think they will need more than the 15 minutes, we appreciate it if they ask ahead of time, and the board will vote on this. Any speaker, 2 for, against, has 5 minutes. Okay. The first petition this evening.
Madam Chair, point of order. Before we begin the old business item, I do have a request of the chair, if I could. So old business item 2-A, the 1 Rains Avenue appeal. My intent is to sit in on this application based off of my understanding of it, but I would appreciate an opportunity before we begin our session to receive any comment from the board. Basically, our Board of Adjustment in New Hampshire Handbook for Local Officials does talk to a member of the board may request counsel from the other board members, and insofar as a vote of those other board members to help them decide on the appropriateness of their remaining as a voting member on a particular application. So I'd appreciate an opportunity if you would grant it to allow us to have that, please. Okay, thank you. So my thought on this particular application, and I know that this is a matter of an appeal of a decision by the planning board, of which Councilor Beth Moreau, who is my wife, is a member of the planning board and was a member of that decision. However, this particular question that is before us is one that has been handed down from the courts, and is a question in my mind of what the allowable review of this board. To me, this is not a question of the appropriateness of the planning board's decision. Rather, it is a question of what is the allowable purview of this board. And in that sense, I believe, as a longtime member of the board, that I do not feel that I'm in conflict in any way, shape, or manner, and that my knowledge and understanding of that could be beneficial to deciding what this board should have or should not have purview over. So that's where I'm coming from, in my belief that I do not have any conflict of interest, but I would be happy to have input from the other board, and then would appreciate if you would hold a vote to help me decide on that matter.
And I appreciate you bringing this up.
Thank you.
Are there any comments?
So I will say that this occurred to me as I was reviewing this application. I did watch the planning board deliberations on this. And one of the, and Mr. Rayom's wife, Vice Chair Moreau, I don't know what her position is now, on the planning board, did make the motion to approve the conditional use permit on the wetlands. That is one of the things that the court has tasked us with as to whether or not this board does have purview of it. I look forward to welcoming other people's feelings on that. But I think that given that that is something that I have a certain determination on, I do think it is appropriate for you to recuse yourself.
Anybody else?
I would concur.
Sorry, you would concur. Mr. Mattson?
Yes, I would also just add that I personally don't see a conflict of interest, and I would appreciate having Board Member Rayom with his input and wisdom. But I guess my minor concern is that there could be a perception of it. I think, again, I don't think that there is an issue, but I guess I don't know how heavily to weight just the mere perception, and I would appreciate the board member Reum being in this process, but
Right. I don't think I'm going to help you because I'm somewhat torn. I do see that your wife voted on this, but we're not really so much questioning what their decision was, so much as deciding if it is in our purview to hear that or send it to the courts.
Yeah.
So I think that is a different, to me, it's a slightly different situation. Would you like us to call legal?
No, I'm fine really with
just wanna
counsel
make
from,
sure
from the
we're all-
board, and again, would appreciate just a vote of the board to help in that determination.
Anything, any more discussion? Is there a motion one way or the other?
Well, I think the decision to recuse is Mr. Rayum, so I think.
No, but he said he would appreciate a vote. But all
Right, so
you-
I guess, if it helps, Madam Chair, I guess I would say that my motion is that I would be not recusing myself and would appreciate a vote of the board to determine if they would agree or disagree with such a thought.
Okay. Is there a second? So that,
A second.
I'm not sure if that's,
oh, yeah.
requires a second, but yeah.
yeah, you're not sure it does?
And then a yes would be that it
A yes
is-
would be that Mr. Rayum remains for the vote.
okay.
Yes.
Well, again, this is a non-binding vote, but it is
I
one that
understand
can
that.
inform my
I
decision.
understand that. We will do a voice vote, so that'll, okay. Mr. Mann,
For
a
David-
yes vote is to allow Mr. Rayum to,
vote,
Participate.
to vote. No.
to participate, yes.
Participate's a different version. I mean, if he wants to
It
add to the
isn't
discussion,
really.
I've got no problem with it. If he wants to vote, that he should recuse
It isn't
himself.
really a different,
Okay, no.
okay. Mr. McDonald?
Yes.
No.
Yes.
And I vote yes.
All right, well, thank you. I appreciate the input of the board. Do recognize that, that there is concerns, but that said, with the merely a split vote, I will continue on with participating in this vote. Thank you.
All right. The first item of business tonight is under old business is One Rains Avenue appeal. As ordered by the Superior Court on February 2nd, 2023, this board will determine in the first instance whether it has jurisdiction over the issues presented by Duncan McCallum, attorney for the appellants, in the January 14th, 2022 appeal of the December 16th, 2021 decision of the Planning Board for property located at 31 Rains Avenue, 203 Maplewood Avenue, and 1 Rains Avenue, which granted the following: A, site approval, B, wetlands conditional use permit, and C, certain other miscellaneous approvals, including an approval related to valet parking. Said properties are shown on Assessor Map 123, Lot 14, Map 123, Lot 13, Map 123, Lot 12, Map 123, Lot 10, and lie within the Character District 4. Downtown Overlay District, Historic District, and the North End Incentive Overlay District. Is there anyone to speak to this?
Good evening. My name is Duncan McCallum. I'm an attorney here in town, and I represent the interveners in the Superior Court case. And to give you an English translation, that means the citizen opponents of the project. As a preliminary matter, I will be quick to say that I think Mr. Rayum should have recused himself, and I do not consider it to be a close case. But I think everybody understands the issue, so I won't comment on it any further. Now, we are here tonight to try to decide what issues that are before the Superior Court this board still has jurisdiction over, and which ones go straight to the Superior Court. The attorneys for the developer are here tonight, Brian Bouchard and Courtney Hertz. I'm sure that they will have something to say about the matter, but I will give my opinion. Now, one of the issues to be considered is, as raised in the appeal papers to this zoning board of adjustment more than a year ago, was whether one of the planning board members who voted on this project, Ray Pizzulo, should have been disqualified because he was sitting illegal, that he'd been illegally appointed. I think, without getting into the merits of that issue, because it's unnecessary for purposes of tonight's exercise, I think that this board should exercise jurisdiction over that issue. There are the basis for the request for him to have disqualified himself has been the subject of quite a bit of paper that's been presented. I think that has been presented to this board. It should include a lengthy letter by the present planning board chairman, Rick Chelman himself, in which he outlined his reasons why he felt that Mr. Pizzulo was ineligible to sit. I think I've outlined it in my appeal paper, and as I say, I don't need to get into the merits right now, but the merits are laid out for you why we think that he was ineligible to serve. Now, the essential reason why I think that this board should entertain an appeal on that issue is this board is in charge of administrative appeals relating to land use board matters. He is a member of a land use board, and this board has jurisdiction over administrative appeals. So that's the first reason. The second reason is that under a relatively recent statute that was passed by the New Hampshire legislature, I want to say 3 or 4 years ago, the legislature made clear its preference that as many issues as possible be resolved at the land use board level in order not to burden the courts. The specific statute at issue is RSA 677:15, Roman numeral 1-A, subsection A. And I think I've got a copy of that I can read you. It's not too lengthy a statute. It says as follows: if an aggrieved party desires to appeal a decision of the planning board, and if any of the matters to be appealed are appealable to the Board of Adjustment under RSA 676:5, Roman 3, such matters shall be appealed to the Board of Adjustment before any appeal is taken to the Superior Court under this section. If any party appeals any part of the planning board's decision to the Superior Court before all matters appealed to the Board of Adjustment have been resolved, the court shall stay the appeal until resolution of such matters. After the final resolution of all such matters appealed to the Board of Adjustment, any aggrieved party may appeal to the Superior Court by petition any and all matters concerning the subdivision or site plan decided by the Planning Board or the Board of Adjustment. The petition shall be presented to the Superior Court within 30 days after the Board of Adjustment's denial of a motion for rehearing under RSA 677:3, subject to the provisions of paragraph 1. Now, reading between the lines, or even not just taking the plain language, in my judgment, what that means is the legislature wants, in order to reduce the burden on the courts as much as possible, the legislature would prefer that the zoning board of adjustment take the first crack at resolving all issues. So I think that the issue of Mr. Pizzulo's eligibility, I think it's a important issue. I think it's one that the zoning board of adjustment should weigh in on, and accordingly, I think that this board should exercise jurisdiction over that issue. Next, I think I just got the planning department's memorandum just short before I came down here. Let me see what the next item is. Okay, granting a wetlands conditional use permit. That's out. This board does not have jurisdiction over that. I saw it a bit differently a year and a half or 2 years ago, but that's the way I see it now. I don't think there's any, I originally took a position to the contrary. I originally doubted it, but at this point, I am convinced that that is the case, that granting wetlands conditionally,
Excuse me, could you speak up a little bit? It may just be me, but.
Yeah.
Sorry.
Old
Oop,
ears.
look at that.
Miracle.
As I say, 2 years ago, I took a different view of the matter, but that's the view I take today, and I am convinced that it is the correct one. This zoning board of adjustment does not have jurisdiction to review the granting or denial of a wetlands conditional use permit by the planning board. Now, the final item on the in the planning board's the planning department's memorandum is granting certain other miscellaneous approvals, and including approval relating to valet parking. That, I think, falls under the appellate jurisdiction of this board, because this board, generally speaking, has jurisdiction over the planning board's decision on granting or denial of site plan approval, and the matter of parking is part of that. Now, as I understand it, the planning board, let me preface my remarks by saying I'm not 100% sure about this part, but my understanding is that the planning board did grant a parking conditional use permit, but that's not the end of the issue. The issue on site plan approval is whether or not the parking plan is adequate, and whether it's going to do its job to reduce parking and make sure that there are no traffic and parking problems in the immediate vicinity of the project. Now, the developers in this case have constructed a plan where there's going to be value. They're going to resolve the parking problem. Everybody concedes that the site is not adequate to support the parking that's going to service the hotel. Their plan is, well, we're going to have valet parking, but there are certain omissions, I think, in the plan, such as who's going to pay for it in perpetuity, who's going to make sure that the valet parking problem lasts for all time. What happens if the hotel or the developers or whoever else is involved runs out of money? You're going to have this big building, you're going to have this big hotel that's going to have an overflow of people and too many cars for the parking that it has, and those are important issues. And since it was part and parcel of site plan review, I think that this board has jurisdiction over that issue. There are sundry other issues that arose during the planning board proceedings. You pretty much have to watch the video of the meeting, because the discussion was sort of disjointed at times. But it all falls under the purview of site plan approval, which is a matter over which this board has jurisdiction. So for that reason, I think that this board should consider and make an adjudication on that, having in mind, again, the statute in which the legislature made quite clear that they would prefer as many issues as possible be resolved at the at the zoning board of adjustment level before we burden the courts with additional appeals. So that is my presentation. You'll have your opportunity in just a moment to hear what the Developers Council have to say about it, but that is my position. Thank you.
Okay, thank you. Other questions before? I'm sorry, I didn't get there fast enough.
One of your other counts was the Conservation Commission, the recommendation to the planning board. What do you have to say about that?
Well, let's see. Let me remember now. Well, the planning, if I recall correctly, the Conservation Commission's only role was to make a recommendation, yay or nay, as to whether the wetlands conditional use permit should be granted. And if that's the case, I think that falls out. I think that falls out of the case too. I don't think that this zoning board of adjustment has any business reviewing that, unless I'm missing something, and unless the Conservation Commission did something other than simply make a recommendation to the planning board. I don't think that that is a matter of this board's concern.
But the court has tasked us to address all of the issues in your January 14th memo. So, I mean, the way I read it, we have to make some finding on that. I think the issue was whether or not the planning board erred in failing to adopt the recommendation of the Conservation Commission.
I don't think this board has any business deciding that. Yeah, unless there's something that the Conservation Commission independently did that has nothing to do with the wetlands conditional use
It was
permit.
not, as far as we know.
Yeah, then I don't think this board has any business, I don't think that this board has any more business touching that issue than it does adjudicating whether or not the wetlands conditional use permit was properly issued.
Okay, thank you.
I'm sorry,
Anything
Mr.
else?
Mantle?
Attorney McCallum, in my review of the meeting and the documents included, did the Conservation Commission ever approve?
I don't remember.
Because on my review of the December 16th, 2021 meeting, they never had an approval. It was a 3-3 tie.
I can't say I remember that. You may well be, I'm not saying you're wrong. You may very
Okay,
well, but
my next
I don't
question
remember.
is,
Please go ahead.
did the HDC ever approve?
Unfortunately, yes, just last month.
Okay. Okay, thank you.
I think they approved that on end of December, beginning of January.
Okay.
Okay, so it was more than last month. It was 2-3 months ago.
Mr. Mann?
Yes, thank you, Madam Chair. So on the matter of the composition of the board and the administrative appeal or an administrative decision, my experience is that those administrative decisions are usually ones that are relative to the zoning ordinance. That is to say, some city official made some determination about something that is in the zoning ordinance related to a property, and therefore that is something that's appealable to this board. I just want to validate, first of all, that in your mind, there is nothing in the zoning ordinance that talks to the composition of the planning board, or is there something that you believe there is?
Well, there's the administrative code, which touches directly the composition of the board. And generally speaking, this zoning board of adjustment has the right to entertain administrative appeals. And I'll grant you it's kind of a close case, but on balance, I think that this board should be entertaining that issue. And ultimately, there's no harm done, because if I'm wrong, well, the distinguished counsel for the developers will bring that to the judge's attention, and the Superior Court will take care of it. But again, in keeping with my theme and the New Hampshire legislature's theme, that they would prefer as many issues as possible be resolved at the zoning board of appeals level before burdening the courts with additional issues. I think this board should accept jurisdiction over that. But I'll admit it's kind of a borderline case.
Okay, thank you. And then in regards to the valet parking provision, and you are correct, the record is somewhat convoluted, but are you aware, is there anything on like the site plan approval, like a note or something, or anything that is like a condition that the planning board put on this in writing that would tie it back somehow to that site plan approval?
Well, the zoning ordinance itself does have other provisions pertaining to parking besides parking conditional use permits. I mean, it's the zoning, where the ZBA gets involved is that there are provisions that regulate how much or how little parking there ought to be. And this board is in far better position than the Superior Court is ever going to be in determining whether or not the parking plan that is being proposed by the developers is adequate. I think That one, I think, is a much, much stronger case for jurisdiction than the matter of, as I say, it's sort of a close case, but I think you should be exercising jurisdiction over the issue of whether Pizzullo was ineligible. But this is a much stronger case because there are other provisions of the zoning ordinance untied to parking conditional use permits, and I think that this board ought to review it.
Okay, thank you.
Yes.
Did the HDC approval change the site plan on this project?
I don't remember. Since it was only last, only last December or early January that they granted that approval. I'm not quite sure I know what the state the site plan was in at that point. And I don't even know if they knew what the state of the site plan was at that point because it has changed over time. So I don't really know is my answer.
So I don't know if we can make an inquiry of staff, because, if the site plan changed, then, I think that, it would have to go back to the planning board for amended site plan approval. Did that happen? Do you know?
I'm going to defer to Planning Director Peter Britz on that one.
If you get his attention.
Are you asking if Peter Britz, the Director of Planning and Sustainability, are you asking if the site plan approval was changed by the HDC decision?
Yes.
No.
Okay, thank you.
Thank you.
Any other last-minute burning questions?
I think not. Thank you.
Thank you.
Okay.
Good evening. Can everybody hear me okay?
Yes. Thank you.
I know you folks have heard from several folks on this matter in the past, and I'm new to you. So my name is Courtney Hers. Attorney Ramsdell, who I know you all have heard from in the past, has retired, and so I'm newly on this case, and I appreciate the opportunity to be here on behalf of the project applicants tonight. As an initial matter, we do agree with the decision, Mr. Rheaume, for you to remain on this matter. I think the analysis that you've laid out is exactly right. And the issue that is before you folks tonight is very limited, and it's been discussed, but I'll repeat it again. The only question that's before you tonight is whether you have jurisdiction over the appeal of the planning board decision. And I know that the board has received a memo from Attorney McCourt informing the board about the law governing this question, which is very clear. It's laid out in the statute in RSA 676(5), subparagraph 3. And it's very clear that only questions involving the construction, interpretation, or application of the zoning ordinance are properly within this board's jurisdiction. Any claims outside those parameters should be dismissed. And furthermore, appeals of conditional use permits must go directly to Superior Court. It's not a question of whether this board has opinions about what happened. I'm certain everybody does. It's a question of law. It's a question of whether the decisions, the issues being appealed, touch on the zoning ordinance. And you will note, folks, that what you didn't hear from Attorney McCallum tonight was a single provision of the zoning ordinance that he claims has been violated by the planning board's decision. Not a single one. If we look at Attorney McCallum's appeal to this board of the planning board decision, I'll go through item by item. So the first section of the appeal, it's actually paragraphs 1 through 7 of the appeal, talks about the issue about whether a planning board member who participated in the vote was ineligible. Reading through those paragraphs of the appeal, again, you'll note that there's not a single provision of the zoning ordinance that's cited there. There are provisions of the city code, and there are statutes. And the argument that's being made is that those two are in conflict. Not a single reference to the zoning ordinance. Tonight, Attorney McCallum suggested to you that there should be jurisdiction over that issue because basically he says the legislature has indicated there's a preference for this board, zoning boards, to decide land use issues first. Well, what we have from the legislature is an explicit statute which tells us which appeals zoning boards have jurisdiction over and which they don't. It's very clear. And in fact, the statute that he read to you tonight said that this board should consider appeals of those matters that are appealable to the ZBA. And that's the question before you, is are the issues that are being appealed appealable to the ZBA? And this question of whether the planning board member was eligible to sit on this matter is not appealable to the ZBA. It has nothing to do with the zoning ordinance. Moving along in the appeal, paragraphs 8 through 10 relate to the issue of the wetlands CUP, which as Attorney McCallum has conceded, is not appealable to this board. Paragraph 11 in the appeal talks about two things. First, whether the planning board should have waited until after the HDC acted. Again, Attorney McCallum, I don't think, is even suggesting that this board has jurisdiction, and it does not. There is nothing in the zoning ordinance that would require the planning board to wait for the HDC to act first. The second part of paragraph 11 appears to be where the argument that Attorney McCallum is most relying on comes. You will see in the appeal that what it says is that the planning board should have waited until certain, quote, unanswered questions were resolved. It does not cite any provision of the zoning ordinance. And I will suggest to you that there's a reason that section 10.234.30 of the ordinance requires appeals to specifically identify the provisions of the ordinance that are involved. And one of those reasons is the reason we're here tonight, so that you know whether you have jurisdiction or not. Now, there has been no argument that the parking issue that is sort of obliquely referred to in paragraph 11 of the appeal, there's been no argument that any provision of the ordinance was violated. But to the extent that the argument that Attorney McCallum's presented tonight is that his clients believe that the parking on the project is, quote, inadequate, that is a question of the parking CUP. The ordinance is very clear. In section 10.1112.143, the planning board may grant a conditional use permit only if it finds that the number of off-street parking spaces required or allowed by the permit will be adequate and appropriate for the proposed use of the property. That's where the adequacy of parking comes in. It's a conditional use permit issue, and the statute is explicit that conditional use permit matters are not appealable to this board. They have to go directly to Superior Court. Moving on to the last two paragraphs of the appeal, I don't understand Attorney McCallum to be arguing that you have jurisdiction, but just to make sure we touch on them. Paragraph 12 relates to whether a member of the Conservation Law Foundation was misquoted during the hearing. And as we can tell from the letter that was attached to the appeal from CLF, the CLF testimony related only to the wetlands CUP issue. It's a sub-argument to the wetlands CUP argument. And finally, the last paragraph of the appeal, paragraph 13, relates to the question of whether proper deference was given to the Conservation Commission. Again, Attorney McCallum concedes that that's not within this board's jurisdiction. And again, it relates to the wetlands CUP issue. And so, folks, I would again suggest to you that while everyone here has thoughts about how things proceeded, may have opinions about the project, the very limited question before you tonight is whether you have jurisdiction. And there is absolutely nothing in the appeal or what's been presented to you by Attorney McCallum that would suggest that you do. I'd be happy to take any questions.
Did this project ever get an approval from the Conservation Commission?
It was a tie vote.
When?
I'm sorry, I don't know the date.
Okay, because everything I've read on this project, it hasn't received it. So that's my first question. My second question, considering the matters of law, and I'm not an attorney, would you agree that if a board is constituted against, in violation of a state RSA, that decisions of a board are at least questionable, if not outright invalid?
It's a little, I'm not trying to avoid your question, I'm going to try to answer it, but it's a little bit of a broad question. I understand what you're asking, but you ask it in a very broad way, and there are lots of factors that can go into that, but what matters for this matter.
I'm not asking about that. I'm asking your opinion as an attorney, okay? If a board is not constituted according to the RSA, regardless of the city, village, municipality involved, is that board's rulings on whatever at least questionable, if not outright invalid?
I can't answer that with a yes or no, and I'm not trying to avoid your question.
Okay.
But what really does matter, sir, is what is before this board. And it's not up to this board to make that decision. It's what's up to this board tonight is to make a decision about whether the issues appealed are within the ZBA's jurisdiction. The legislature has set out a very specific structure for how matters are to be handled before different boards, before the court, before the Housing Appeals Board, before whatever jurisdiction has, whatever matter has jurisdiction. And so whether or not there's a legal issue to be decided, it has to be decided in the proper forum.
Okay.
And this is not the proper forum for that question, as the statutes make plain.
Do you think it's proper for a board member to misquote somebody on a totally different project and use it to influence, sway, or, misinform other board members?
Well, I'm not aware that that happened, but what matters for this board tonight is
Okay.
whether that's a matter that's before this board, and this board has jurisdiction. And this board does not have jurisdiction because it is not an issue that touches on the zoning ordinance. The statutes are explicit, Mr. Mantle, and there is no way around it. The statutes say what this board can consider. There are courts, there are other forums for arguments to be heard. Obviously, Attorney McCallum has brought plenty of arguments before plenty of boards and courts, and each one has to play its role as the legislature has laid out. This board is a function of statute, and it only has jurisdiction over the questions that the legislature has given it jurisdiction to hear.
Thank you.
You're welcome.
No more questions.
Yes.
So just, I will say, just for the record, Attorney Ramsdale was a very fine attorney. I hope he has a good retirement.
I will do my best to live up.
And I will say that from my own perspective, I didn't know anything about this project until we got this appeal. This is the first time that we are hearing this appeal. And I think whatever decisions we make, we have to make very clear to the court that it never came before us. First time I really delved into this was watching the December 16th Planning Board meeting and reading through the materials. So I think I can pretty much figure out all the counts, all the complaints, so to speak. The parking, I think, is underdeveloped, frankly, by Attorney McCallum's letter. I also think the planning board really rushed that at the end. And for me, it was very difficult to figure out what was the cup, what was parking requirements, the whole valet parking thing. It was just, I found that extremely difficult to follow. You know, I don't know if, you know, so I just, that's just a comment more than a question, but it's very unclear to me what it is we're supposed to be reviewing on that, so.
If I could respond quickly to that, but
Of course, yeah.
I think what you have to be governed by is the appeal that's been filed, right? You have a document that lays out what issues the appellants are appealing to you. And all it says in there on the issue of parking is that there are some unanswered questions about valet parking and whether there's an adequate amount of parking. And that clearly falls within what the ordinance talks about for the parking CUP. Now, maybe there were other arguments that could have been made. I don't know. But they weren't made. And you have to be limited by what appeal questions are being presented to you.
Understandable, but it could be part of site plan approval, which is appealable to this board. So-
But only if it touches on the zoning ordinance, right, and not a CUP issue. And here, the only parking issues that are even obliquely mentioned relate to the CUP.
Understandable, but also, you know, since we were tasked with watching the planning board's deliberations on this, it also was very rushed and not clear. So, thank you.
Thank you.
If I may, just, could you further elaborate on Ms. Marchison's question? Because I am trying to wrap my head around the idea that only the CUP would apply to the parking discussion. Do you have any further evidence or description of why you feel that that is the case?
Well, like you folks, I'm limited by what the appeal says the issues are being brought to you, right? And to the extent that the appeal tells us anything about, let me pull up the exact language. It's in paragraph 11 of the appeal, the only reference to parking, the only issue that's being brought to you by the appellants is the second half of paragraph 11, which says there were many other unanswered questions which came to light during the hearing. The planning board should have waited until they were resolved. It says it was never settled who was going to be responsible for paying for valet parking in perpetuity and who was going to be responsible for enforcing the stipulation that such valet parking be provided, as the existing on-site parking provided for by the developer's plan was and is admittedly inadequate. I don't agree with you with the assertion that it's inadequate, but what does matter here is that that's all that the appellants are arguing. Basically, that the parking is inadequate. And the ordinance is explicit. It's section 10.1112.143 that talks about conditional use permits for parking and says that they will be granted if the planning board finds that the parking spaces will be adequate and appropriate. That's what the ordinance says about this issue. So if we tie what the appellants are arguing about parking back to the ordinance to see if it fits within this board's jurisdiction, the only place it fits is within the CUP section, and that's outside this board's jurisdiction. So I don't know if that answers the question you're getting at.
No, I appreciate the elaboration. I really just wanted to understand your thinking. And again, you're citing which paragraph in the zoning ordinance for that?
10.1112.143.
Okay, thank you.
Certainly.
Any further questions? Okay,
Thank you.
thank you. If there are no further questions, we will open up. Well, this is an appeal.
Yeah, it's an appeal.
Oh, I'm so en route. Okay, people, so what do we,
Discuss amongst the board?
Yeah.
Come to a decision?
yeah, what would you like to do?
I'll share my thoughts at this point.
Please do.
Board member Margison mentioned that it hasn't, this case hasn't been before us, but I have, out of my own personal interest, I have followed this case. And I guess I would point out that as much as I would like to be able to take the load off of the Superior Court, to me, I'm inclined to say that we don't have jurisdiction. You know, it's already been admitted that over the conditional use permits, that's not even in question. So it's really down to the parking. And also hearing the comment that the HDC didn't change the parking or the site plan, that would also weigh into my consideration.
Anybody else? Yes,
So
Ms.
I-
Margison.
So I think that, it would be helpful for purposes of the court, because I'm an attorney and you like to make courts happy, is to go through and decide perhaps on each of the grounds, and make our findings to the court.
It's certainly something we can do.
Yeah, so,
Yes.
but it's up for discussion by the board as to how they want to, how we
think that
want to
makes
deal
sense.
with that.
Yeah, Madam Chair, I would agree with Ms. Margison. I think there's 3 points that the court sent back to us. I think maybe independent discussion and a finding of facts on each of the 3 of them could be beneficial separately.
Well, I actually think it's because the court said that it was the January 14th appeal letter. So I think we have to go through the appeal letter. A big portion at 1 through 8 is the ineligible member, and go through those, because that's the three things were the city's summation of it. But I think it would be useful to, the court wants to know based on the January 14th letter.
Okay.
I guess also as a further thought, because of my inclination to that we don't have jurisdiction, that would also support my position that Board Member Rayum is. It wouldn't be a conflict of interest for him to vote on the matter.
Okay. So, how would you like to break it up?
Well,
I'm not,
okay, well, this is how I would do it.
yes, and we can all,
So I think referencing page 32 of the packet, the January 14th letter from Attorney McCallum, and the grounds for appeal are paragraphs 1 through 7 deal with the ineligibility of Mr. Pizzullo as a member of the planning board. I can make because I don't want to lead too much, but I think that there clearly is a conflict between the RSA and the city ordinance. Whether or not that triggers Winslow v. Holderness and makes that vote ineligible, I don't believe is within the purview of this board to decide.
is there further discussion about that?
In regards to this, I guess I definitely see the conflict of interest back on that vote on the planning board, but I don't see that as being under our jurisdiction.
So, and
Mr. Rayum.
I'm sorry, Madam Chair. On this specific issue, and again, not passing judgment in any way, shape, or manner on what the appropriateness of what happened with the planning board is or is not, but I guess my viewpoint on the question is there something in our zoning ordinance that would affect the composition of the board and who should be on it? I did not see anything in the applicants or the appellant's discussion that would indicate that they cited anything specific to the zoning ordinance. I couldn't find anything in the zoning ordinance that's tied to it, and I think the applicant's representative also, or the appellant's representative also, kind of indicated that there was it is a tenuous tie at best, and I guess with that, my sense is that this is not something that this zoning board should be reviewing.
Okay,
I agree.
okay,
The composition of the planning board has been in question for a number of years now. When it was first brought up several years ago and was pointed out to then city manager John Bohenko, he made changes immediately for the specific reason of validating any planning board decision.
right.
The changes are no longer there. As Mr. Rayoma has already said, there's nothing in our planning ordinances about this. So I would immediately look at the state RSAs, which, if you're reading them, versus how our planning board is made up, we're clearly in violation. But again, that's state law. We don't have jurisdiction over that. But it makes it appealable to Superior Court.
I guess I would just clarify, I may have misspoke. It was less about the specific board member and more about the difference between the city versus state statute that I could see the potential conflict there.
So where we are now, if there is no further discussion, we would be awaiting a motion on paragraphs 1 through 7 about Mr. Pizzullo's right to vote on this issue.
Well, I will, it's whether or not we have jurisdiction over it.
Right, whether
yeah.
we have jurisdiction over this situation, exactly.
So I can make a motion if
Okay.
people want. So I would move that the complaints in paragraphs 1 through 7 of the January 14th letter, the ZBA has no jurisdiction over.
Is there a second to this?
I second.
Okay. Is there further discussion? Would you speak to your motion?
For everything that I just said, there is a, I don't want to get into the merits. I think that there is a conflict, and whether or not this triggers and fits into the holding of Winslow v. Holderness is a matter for a Superior Court to deal with.
Yeah.
Anything to, okay. So then a vote yes is a vote to say that this is not an appealable situation. Mr. Mannell,
Yes.
Mr. MacDonald,
Yes.
Ms. Margison,
Yes.
my goodness, what is wrong? Mr. Mattson,
Yes.
Mr. Rayum,
Yes.
and the chair votes yes. So that is the first part of our decision-making for tonight. After that, in the appeal letter, I believe what comes next is the CUP for the
And that is
land use and
paragraphs 8 through 10.
Right. And the, okay, I will let you speak. Is there someone to
I
speak
don't-
to, not you, is there someone to speak to this? Because
I don't want to keep speaking.
Madam Chair, I would just say that the appellant's representative has stated that they do not believe it is appealable to the Zoning Board of Adjustment.
And our memo has also, from the city, has also made that quite clear, so.
There does appear to be a certain unanimity that is not appealable to this board.
Nevertheless, we will vote on this. Is there a motion?
I'll make a motion that we do not have jurisdiction over paragraphs 8 through 10.
Just to be thorough. Is there a second?
I'll second that.
Okay, thank you. If there is, do you want to speak
No,
to it?
just for all the reasons we've stated.
If there is no further discussion,
Okay, what's this motion now?
a
For?
yes vote says that we do not have any jurisdiction over the CUP part of this appeal.
The wetland CUP?
Yes. Yes. I'm sorry, paragraphs 8 through 10, yes.
Yes.
Okay.
Okay. Mr. Mannell,
Yes.
Mr. MacDonald,
Yes.
Ms. Margison,
Yes.
Ms. Mattson, Mr. Mattson,
Yes.
Mr. Rayum?
Yes.
And the chair votes yes as well. Okay. Okay, so paragraph, we didn't.
11.
Yeah, 11 through, 11
Well, I think
is-
they sort of become individual at that
I
point.
know.
So,
11 is the wetlands conditional use.
no, it's it's,
Oh, mine is,
It begins with that, but it moves on.
it moves on, right, and then it goes into the.
site plan
the
approval and the
right,
HDC.
right.
HDC.
So HDC and site plan.
I think this is probably the most, this is the tougher one for me because I don't think that it's very well developed. I don't know how the parking outside of the cup actually ties into the cup, into site plan approval, which would be appealable to this board. I think it is on the appellants to sort of plead that out, but also, to be fair, the planning board did not do a good job with this when I watched them. But I don't know, let me just hear from other people. I don't know.
Well, obviously, if you're watching the planning board meeting, the whole application was rushed, in my opinion. considering that the planning board was still waiting for an HDC approval, was still waiting for a Conservation Commission approval, I didn't see the need to get this done. They had time. They had plenty of time, especially with the questions that were asked. That being said, I've seen applications rush through before without any errors. I've seen applications that were deliberated for months and approved that had errors in it. So, is the parking appealable to us? Well, of course it is. Is there anything they did wrong as far as applying the zoning and the ordinance in place? Not that I can tell. What concerns me more is how planning board members rush through the process or gave misinformation to sway, obviously, other planning board members. But again, that's not appealable to us. So that's where I'm at right now.
Okay. Mr. Metz.
Yeah, I definitely see where Board Member Mano is coming from, and I share some of those concerns. I guess the catching point for me is that the burden would be on the appellant, and there's no specific provisions mentioned in the ordinance that regarding the parking independent from the conditional use permit, which we don't have purview over.
Mr. Bayham.
Yeah. And again, I would caution the board, our responsibility here and everything that I'm talking to this evening is our jurisdiction over this and not a decision, at least at this point in time, on the merits or demerits of what the planning board actually did. There's the discussion at the beginning of this paragraph that talks about timing versus the Historic District Commission. Again, looking through the zoning ordinance, I don't know of anything in our zoning ordinance that really talks to timing of boards. It's certainly a discussion that we often have, even in this board, on whether we make our decision first or wait for an HDC decision. It is, well, I've referred to it in the past as land use board ping pong, where there's certainly a possibility that a applicant could get stuck in, being sort of settled between boards. But that said, I don't think there's anything in our zoning ordinance that specifically talks to the necessity of one board waiting for a decision from the other board. So again, outside of our zoning ordinance, I don't think that would be because it's outside of the zoning ordinance, I don't think it'd be something that's appealable. The valet parking, in my mind, is the most questionable aspect of this whole discussion in terms of something that could be potentially appealable to the zoning board. There is the conditional use permit, and the paragraph that was cited by the developer's representative certainly talks to it, but and starting to put additional wrinkles into the granting of a conditional use permit. Did the planning board wander into territory that really is starting to affect other areas of the zoning ordinance? I do think that's a legitimate question for us to be considering here, and maybe the one aspect of this where there is something where they either intentionally or accidentally tiptoed into portions of the zoning ordinance that would be something that might have eventually had to have gone back to this board for a determination on it because it is not clearly covered by the zoning ordinance. Now, there is also in that paragraph 10.1112.143, it talks to granting of a conditional use permit. It does say, in making this determination, the board, that is the planning board, may accept, modify, or reject the findings of the applicant's parking demand analysis. So I guess would modify open up the door for the planning board to be able to say they are in keeping with the concept of the conditional use permit and therefore making it something that this board would not be reviewing Or did they wander outside of that? And I don't know if I have a definitive answer on that, but I think that's something that's the point that this board needs to be trying to figure out. My thoughts.
Okay. I think, I agree that the parking is the stickiest issue, but it's made even fuzzier for me that the main feature they're talking about is whether to valet or not, and who's going to pay for the valet, rather than are there enough spots, or, you know, the more specifics that would speak directly to the zoning ordinance. So I think for me, that's the issue. I absolutely agree that whether the HGC or the Conservation Committee spoke first, last, or ever is not something that's in our jurisdiction, because there is no ordinance that says it must be so, one way or the other. So, so I'm feeling overall that this is not in our purview. But I would welcome a motion now if there is no further discussion. Let me just
I think
ask
we have
you
a
one
split
thing.
over there.
Would you benefit from hearing from Attorney McCourt in any way? No?
No.
Just,
No.
just checking. Or Peter Britz.
The court's foisted this back on us. I think it's our
It's
our
us.
deliberation.
Okay, to move this along, I will make a motion that we do have jurisdiction over item C on the agenda. Certain others, miscellaneous approval, including approval related to valet parking and whatever else is in his appeal.
I really think we need to take it by the paragraphs of the
Oh, okay.
letter. That's, as I read.
I'm going by
the
the
word.
agenda.
Oh, yeah.
Right, but.
Since they broke it up
miscellaneous,
into
I think,
three.
makes it- Since we've broken it down so far
Okay.
already, we might want to
And even within
specificity.
11, there's the HDC issue and the parking issue. So we have an 11A and an 11B.
And there's nothing in our ordinances about parking CUPs have to go to Superior Court, correct?
The state,
CUPs
yeah.
in general
Have to
go
go
to
Superior
court.
Yeah.
Okay.
Yes, yes.
If I could just make a comment, I think I briefly mentioned it before, but now that we're talking about paragraph 11, something that swayed my decision is that the HTC didn't make any changes to the site plan that was before them regarding parking and such.
Would you like to break it down into Conservation Commission, HDC, and then take parking separately?
Well, I think 11 is HDC and parking.
Okay. Then we will do it. They just seemed less akin to me.
And I could handle the HDC, the 11A,
Okay,
if that's agreeable to everybody.
yes,
So-
please do.
I would move that the ZBA does not have jurisdiction over 11 to the extent that it talks about the Historic District Commission that the planning board should have waited to see what the developer's plan was going to look like after having been vetted by the HDC. The concurrent processes are allowed in our zoning ordinance. I think the only restriction on a certificate of approval by the HDC is a variance from this board. So I would move that we do not have jurisdiction over that issue.
Okay, is there a second?
Second.
Okay, thank you, Mr. Mattson.
I'm kind of making an argument on the merits, but anyway, so.
Do you have more to add to that?
No.
Do you have more to add to that motion? If there is no further discussion, we will vote. Mr. Mantle?
No.
Mr. MacDonald?
No.
Ms. Margison?
No means we don't have,
Right, no means we don't have jurisdiction.
I think it's yes,
No,
How did
no,
you- how did you
yes
phrase
means
it?
we don't have.
jurisdiction.
I'm going to start this again, sorry.
Okay, yes means we don't have jurisdiction.
Correct.
Ms. Margison's motion was that we do not have jurisdiction in this area. So a yes vote means that we do not have jurisdiction in this area. Mr. Mantle?
No.
Mr. MacDonald?
Yes.
Ms. Margison?
Yes.
Mr. Mattson?
Yes.
Mr. Rayom?
Yes.
And the chair votes yes. I'm sorry, I wasn't trying to correct you, but
No,
just to
no, I
clarify.
understand.
You can vote however you like.
And now the valet
So
parking.
we do not have jurisdiction. And now, valet parking.
If I could also just make a comment, I appreciate for our own sakes breaking this down by paragraph. I know it also benefits the Superior Court, but I think it's good for everybody.
Thank you.
That's how I
That's great,
prepared,
that's
so. It's all I can do. I can't move too well on the fly.
Yeah, who would like to take the lead on this?
I guess I would have a general comment or question, which may or may not involve legal counsel, is by deciding on this, if we decided that we did have jurisdiction on this one portion of parking, how would that affect the outcome of the total procedural situation?
I believe, and then I would ask for attorney, that we would hear that portion here.
Yeah.
And then it would go back up to Superior Court.
Okay. But we would make a decision on that portion, and the Superior Court would hear that as well as the others?
Yes.
Okay.
Only if it was appealed to Superior Court.
Yeah,
Yeah.
only if.
Oh, only if, yeah, this, okay.
Thank you.
Or we could ask our attorney.
Did we just take care of you?
Well, I would just say if they got a little closer, if you decide that there is jurisdiction over any of the counts claimed by Attorney McCallum, we would all await further instruction from Superior Court based on motions of the party. And Madam Chair, if I may,
Please.
make a recommendation to the board on how to help work through some of these issues. If the board or any board member wants to make a motion that that this board does have jurisdiction over any of the claims raised by Attorney McCallum, I would humbly recommend to assist the court, and as we move forward with this, that board member cite what part of the zoning ordinance was misinterpreted, misconstrued, or anything like that. I would just humbly recommend that you do that. Thank you.
Thank you. So,
More homework.
that's something else to think about.
Yeah, and that would be in regards to the construction, interpretation, and application of the zoning ordinance. We would cite the specific.
Particularly in what, yes.
Yes, okay.
Yeah,
Yep. If, yes,
yes.
Okay.
If we feel that we have jurisdiction.
correct.
Yes.
Okay.
Nobody?
I'll make a motion that this board does not have jurisdiction over the paragraph 11 that talks about valet parking or parking in general without, yeah. And my reason would be because there's no specific provisions of the ordinance cited.
Is there a second?
I would second for discussion, Madam Chair.
Okay. So is there discussion? Is there discussion on this motion? The motion is that we do not have jurisdiction because there is no specific. Oh, okay. Okay. Yes, Mr. Ram, for discussion purposes.
For discussion purposes. I am torn. I do think that this was probably, as has been pointed out, probably the most convoluted aspect of it. To me, the only word in our zoning ordinance that may give the planning board an out here and put this under the cognizance of the conditional use permit, because I think that's key, is that in saying it doesn't apply, it's something that this board does not need to review. It's because it was within the overall purview that the planning board would have had in regards to a conditional use permit. And I do think that the word modify, which I did emphasize before in our second sentence of section 10.1112.143, in making this determination, again, talking about granting the conditional use permit, the board may accept, modify, or reject the findings of the applicant's parking demand analysis. Now, it does kind of talk to a demand analysis, but certainly all of that wraps into exactly how the parking would be handled in terms of some of these more particulars that that the appellant has brought up here. And I think the word that gets them off the hook in my mind is the word modify, and that does give in our zoning ordinance a broad mandate to the conditional use permit, puts it under that envelope, and says that this board would not have jurisdiction over it because it is covered by the umbrella of the conditional use permit. That's my thought.
Mr.
Yes.
Mattson?
I don't know if it would require modifying my motion, but yeah, in addition to the citing a specific provision of the ordinance in the appellant's paragraph 11, that would we're only consider we already it's been conceded that anything regarding conditional use permits automatically goes to Superior Court. So the parking that would be independent of a conditional use permit for the parking. Yeah.
Does the second accept that amendment?
Yeah, I mean, I think it's an essential aspect
Right.
of it is that as has been made clear through the ordinance, the law really, is that conditional use permit is not appealable and has been agreed to in the prior case regarding the wetlands conditional use permit. I think there's broad agreement that the law is pretty clear on that point.
Ms. Marchison?
So I think we're going a little far because I think we're reading into a lot of the count that's not there. It's very difficult for me to know if we have jurisdiction, given the pleading, and I would just simply state on that ground we don't have jurisdiction. But we're reading a lot into, taking this out of our jurisdiction, that it's a cup. I don't know. So.
For me, the very specifics here that I'm looking at in front of me is a debate about who's responsible for enforcing the valet parking, and that, to me, clearly doesn't seem like that much of a land use issue.
Yeah, and I guess also for a point of discussion, my understanding is that the burden is essentially on the appellant or the case before us is to prove that we do have jurisdiction. So as Board Member Margison stated, if there's not enough information to decide that we do have jurisdiction, we would decide that we don't have jurisdiction, or?
If I were to be forced to make a decision right now, that's how I would say it, because, obviously, if this had come to us, that issue may have been developed more, but the command of the court is that we are to read this letter and decide whether or not we have jurisdiction, and to me, it's not clear from this that we have jurisdiction, so it would be my...
So we only have two options, right? It's there isn't a third option. It's either we do or don't have jurisdiction.
No, just
That's it?
Okay, just to clarify.
Oh.
Okay, thank you.
So the motion on the floor is that we do not have jurisdiction over the parking issue for the reasons that have been stated. If there's no further discussion, we will vote on this. Mr. Mantle?
No.
Mr. MacDonald?
Yes is
Yes is that we do not have jurisdiction.
yes.
Ms. Marchison?
Yes.
Mr. Mattson?
Yes.
Mr. Rayam?
Yes.
And the chair votes yes. So we have decided that there is no point, there is not one point on which we do have jurisdiction in this request, this appeal to us. Okay. Is there some, yes?
Two more paragraphs.
Two more.
Oh, I'm sorry, I thought that we had been covered. Okay. Oh, the conservation, in my mind, I did that with HDC. Conservation Commission,
Law Foundation, actually, first.
Okay.
Paragraph 12.
Conservation Law Foundation. Well, can we do those together, do you think?
I wouldn't.
You
no.
wouldn't? Okay.
I think they're
Then you
separate
may
issues.
choose to do that as you wish. All right. Paragraph 12 speaks about the Conservation Law Foundation and a difference of approval or not approval. Would somebody like to make a motion, speak to this?
I think the issue is whether or not, I mean, having looked at the record, I think that the Conservation Law Foundation was misquoted. And how much that influenced the other members of the planning board, I don't know. I also, I think that that is something that, is not probably within our purview. So.
Other opinion? I'm sorry, Mr. Mattson, I saw your hand.
I would just, I would share the concerns of the other board members, but my opinion on that matter is separate from whether or not we have jurisdiction, and,
Yes, thank you, Madam Chair. So I would say that this paragraph points towards the wetland conditional use permit. So in that sense, would not be something that's covered. And in addition, as Ms. Margison has pointed out, there's really nothing here that talks to a specific paragraph of our zoning ordinance elsewise. So I would agree.
Would anyone like to make a motion?
I'll make a motion that this board does not have jurisdiction regarding the paragraph 12 discussing the Conservation Law Foundation being misquoted and the concept of that affecting the planning board.
Is there a second? Is there a second?
Second.
Thank you, Mr. McDonald. Okay, is there anything else that you would like to add?
Nope, just for the reasons we've stated.
That you would like to add? No. Okay. Then a yes vote says that we do not have jurisdiction to look at the Conservation Law Foundation issue. Mr. Mantle,
I will vote yes, only on the fact that it relates to the wetlands CUP, which we don't have jurisdiction on.
Mr. McDonald,
Yes.
Ms. Margison,
Yes.
Mr. Mattson,
Yes.
Mr. Rayam,
Yes.
and the chair votes yes. Okay, now we have come down to considering the Conservation Commission question.
We just did that.
No, that
No,
was
that
the
was-
Conservation Law Foundation.
Oh.
We are now on paragraph 13. Lucky 13.
Lucky 13.
Okay. Yes.
Madam Chair, I'll start off the discussion on this paragraph. There's nothing in our zoning ordinance and nothing that I think binds the planning board to uphold a recommendation from another board, and I don't think there's anything in our zoning ordinance that talks to that either. So my sense is that this is not something that is under the purview of this board.
Okay. Mr. Mattson?
I guess I would just add that during the previous discussion, it was mentioned that it was a 3-3 vote that was tied, which I guess is that a, again, it's still only a recommendation, but that's not necessarily an approval or a disapproval.
It probably would have been a not, it was a tie.
It didn't fail to
so-
pass,
right,
yeah.
So it didn't happen, right.
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 But yes, again, this would relate to the conditional use permit, and then also the lack of a specific provision of the zoning ordinance being stated, or not being stated.
Okay. Is that a motion?
I'll make a motion that the zoning board of adjustment does not have jurisdiction regarding paragraph 13 discussing the Conservation Commission and their recommendation to the planning board.
Okay. Is there a second? I can't do this.
I will second.
Thank you. Okay, if there is no further discussion,
No.
then we will vote. A yes vote means we do not have jurisdiction. Mr. Mantle?
Yes.
Mr. McDonald?
Yes.
Ms. Margison?
Yes.
Mr. Maxim?
Yes.
Mr. Rayum?
Yes.
And the chair votes yes as well.
That concludes our.
And that concludes our discussion on the first item of the evening.
Can I just want to add, I saw this for the first time. This is not for the Superior Court. I saw this for the first time and became aware of this for the first time as a result of this appeal. This project was very rushed. And then for reasons I'm not really sure, but it was very rushed. But I will note that and this is again not our purview, but in watching the presentation and reading the minutes, the planning board is not applying the conditional use permit correctly. They have to meet all 6 criteria. And for purposes of city staff, I think the command is very clear. The ordinance says they shall and all, and that is mandatory, and they are supposed to meet all 6 criteria. And in the meeting minutes, it says Vice Chairman Moreau disagreed with those who feel they have to meet every criteria exactly. I think going forward, there should be different advice to the planning board as to how to handle wetlands for CUPs for CUPs. CUPs for wetlands, sorry.
All right. Now we go to item C under old business, which is not a public hearing. It's the request of Ms.
Item B, did you
Item
specifically
B.
postpone that?
It was postponed.
It was
We
postponed.
yeah, we did them together with the
We
first
did
one.
it at this,
Okay.
yes.
Okay, yes.
Yep. Thank you, Bill. The request of Nisley LLC, owner for property located at 915 Sagamore Avenue, whereas relief is needed to demolish the existing building, construct new mixed-use building, which requires the following. 1, a variance from section 10.440 to allow a mixed-use building where residential and office uses are not permitted. 2, a variance from section 10.111.20 to allow parking to be located in the front yard and in front of the principal building. 3, a variance from section 10.1114.21 to allow 2 driveways on a lot where only 1 is allowed. Said property is located on Assessor Map 223, Lot 31, and lies within the waterfront business district. Is there anyone to speak to this? No, we're not just
We
doing,
don't
I'm
have it.
sorry, I'm on automatic. What would you like to do with this?
Point of inquiry, Madam Chair. So
Yeah.
what is taking place? What is the just want to make sure that we're all on the same page as to regards. We have closed the public hearing on this, and we are taking it up
Anew,
based off of that.
yes.
As if we are in our deliberation space
That was one of
after
the-
the public hearing had been closed.
And
Okay.
that is one of the choices we had, and we chose to do this.
Yeah, I just wanted to make sure that we're all on the same page with that.
Yes.
Thank you.
Yes. Yes.
All right,
Mr. Ray.
Madam Chair, I'll start off with making some comments. And refamiliarizing myself again with this application after having had some time away from it. Again, this was a request to construct a mixed use, including residential and offices in the waterfront business district where those uses are not allowed. Some of the things that the applicant has put forward in their written word and reviewing the testimony of the applicant's representative talked about that there's a property directly across Sagamore Creek that is used for professional office space, the Seacoast Mental Health. I found that a spurious argument in the sense that that professional office space is not in the waterfront business district. It's actually in the mixed residential office district where that is, in fact, allowed. It talks about the feasibility of using of the waterfront, but and the fact that the waterfront is very minimal, and that negatively impacts their ability to meet the expectations of the waterfront business district. I, again, find that argument a bit wanting. There are some of the uses that are allowed in a waterfront business district, admittedly not many, and it's restricted greatly because that is what a large number of the people, certainly that I've seen in various public forums, when talking about the waterfront business district, there is still a strong attachment to trying to preserve some aspect of Portsmouth marine heritage, certainly something that we are trying to celebrate here in our 400th year since the founding of Portsmouth. And with that, there are some options that really don't necessarily require water space at all. And in fact, this waterfront business district does include several parcels, which the applicant had correctly pointed out seem to have mostly residential uses, although there does seem to be some boat storage as well, but that can be done by a residential, as part of a residential use. But one of the options is marine-related research and development, which does not necessarily require waterfront space to be able to go and have that being either in totality or at least, if the applicant made that in part of what they are trying to put forward here, that is, at least a recognized use that doesn't necessarily require waterfront. So I think there's a disconnect there where a lot of what the applicant's argument is, hey, I'm in the waterfront business, but I really shouldn't be. I only have this teeny tiny little bit of water that's really very tidal, not terribly useful towards progressing a waterfront business use. I think there are admittedly very limited, but a couple that, and certainly this waterfront or marine research and development could definitely be one. Certainly University of New Hampshire has its ocean engineering. Is there some spin-off from that could be something that could be put into this space? It could certainly be a possibility. And I think that there are other properties, both in this area and other portions of the waterfront business district, that are similarly burdened where there really isn't a useful water presence, yet they still remain in the waterfront business district. My other concerns with the application is simply that what is being proposed here is very generic. And again, we hear repeatedly, or I've heard repeatedly, in my experience, that there is a preciousness about a waterfront business district. What is being proposed here really could end up in many other zones in the city. In fact, I would say this would be an ideal project for our Gateway District. I think it's the exact kind of thing that we were sort of envisioning for that area. It could even end up in downtown with sort of an office retail use on the first floor with residences above, although the applicant's also proposing that there is some residency on the first floor. But definitely a Gateway District. There's lots of other places this could go. It doesn't need to burden our few precious waterfront business properties, at least as proposed. So in my mind, I think that what has been proposed here is really fails on both keeping with the spirit of the ordinance, and I think that the hardship argument that's argued by the applicant in terms of its suitability for the waterfront business district zone is also spurious. So those are my initial thoughts.
Thank you. Yes, Ms. Marches.
So there is, so for the record, I went back and I watched the presentation on this and our deliberations, and also I reread the materials. There is some benefit, I think, sort of looking at it afterwards. You're like, oh, but I will say that I think in the spirit of what Mr. Rayom is saying, I didn't support this application that night, and I still do not support it. I think that in terms of hardship, this waterfront business allows for the sale of marine goods, groceries, and ice That is another use for this. This is a use variance, which I understand under law use is not that different from area. However, I mean, we are rezoning this property. And I take that very seriously. And we'd be rezoning it to mixed residential business. There are 12 work units. The purpose of a mixed residential business unit is to provide a transition between commercial and residential. You know, I don't see any real commercial properties there. It's more on the downtown, the edge of downtown. And so I think it even does not fit the spirit and intent of the mixed residential business district. Also, the density, this would allow for 12 units. The highest amount of density units that are allowed in mixed residential business is 8. So it's even in violation of that, that provision in the ordinance.
Yes, Mr.
Yeah, I'll just add some of my comments. I agree with the comments made by the other board members so far, and I guess one thing is, yeah, it was definitely the density of this project was almost hidden in the fact that waterfront business doesn't have any criteria regarding that. And then similarly, the preciousness of the waterfront business district. I guess I'm a little bit more torn, perhaps. I think the property is somewhat underutilized, and I would like the idea of, through stipulations, being able to require one or more of the offices be used for waterfront business purposes, and also reducing the density proposed. But I could also get on board with denying the application, which I guess would allow for potential future applications with it being appropriately different.
Anybody else? I found you quite convincing, but it is like this little desert in the middle of residences. And I do know that there are many uses for waterfront business that don't require a lot of water, or any water. You could be a fish market, or you could do storage or repairs. I guess the boat needs some water to be repaired. But I think that because of the rezoning, which we take so seriously, and because of the density that would be suggested, that I would find that I couldn't support this application. And maybe we could say, yes, a half of it needs to be used for waterfront business, but they're not really retail. They're offices, and while that might work, it might be a burden that is not a reasonable burden. I don't know. On the other hand, we can't say that tomorrow someone will come along and want to do waterfront, and maybe this isn't the best zoning for this site. But then again, not something we can determine. So, is there further discussion? Thank you. My eyes are always in the wrong way.
I guess I would just add that part of my consideration in my previous statement is that I feel that, I mean, perhaps it's a little bit speculation, but that something will be happening to this property. So if we don't deal with it now, we'll be dealing with it at some point. So somewhat a kind of like setting the criteria would, or the stipulations would help that move along. But if the other board members don't see that as appropriate, I can understand that.
Did you want to say something, Mr. Mayor?
Yeah, I mean, I do think that there are some possibilities. I don't want my comments to be taken as strictly like the only thing that could ever be here is waterfront business, and that no variance could potentially be given because of that fact. I just think that this particular application, with its heavy emphasis on other uses, no real attempt at an emphasis on honoring the waterfront business district. And I thought through some work by the applicant, and maybe they were never going to get there, but I thought through some work by the applicant that they could maybe get there and find some way of really tying that aspect of it in and modifying the design somewhat to be more respectful of that aspect of it. Could have potentially had a project that could have been something that would have met our criteria. But what's being proposed is just so completely out of the intent of the waterfront business district. You could sometimes make an argument that nearby properties are in another zone and therefore improperly zoned. That really don't have that argument here. Could have maybe made an argument that a single-family home might have been appropriate because it is surrounded by 3 other, maybe multiple other waterfront business properties that have single-family homes either in whole or in part on them. But that is not what the applicant is looking for here. So with all that, I simply think it's too far of a reach, does not meet our criteria. And it's also slightly egregious that it does currently have a conforming use or did most recently have a conforming use, and now asking to negate that.
Any other comments?
No.
I'm sorry, I wasn't really looking at you. Is there a motion? Would someone like to make a motion?
I've talked enough.
Go ahead, David. You haven't made a motion yet.
Well, my last time I made a motion on this application, it got me into trouble, but I will, I'll give it another shot.
You can get yourself out of trouble.
Madam Chair, I move that we deny the applicant's request.
Second.
Okay, thank you. I will speak to my motion.
Please speak.
To speak to my motion. As always, variance request requires to be granted that we find that it passes all 5 of the tests that are put forward. To deny it, we only have to have it fail at 1. I do actually think that it fails at 2, at least in relation to what is being requested here. It fails in 2. The first of those being granting the variance would observe the spirit of the ordinance. I really do think that in particular for the Waterfront Business District and the way that it's been set up by the Planning Board and approved by the City Council is very prescriptive, really has a very distinct vision in mind of what the importance is of these parcels and what their uses should be. So more so than perhaps in any of our other zones, I think there's a real perception there as crafted through our zoning ordinance that tells us that, trying to keep waterfront business being there is critically important to the maximum extent possible. So I really find that is in violation of the spirit of the ordinance. And I think the hardship criteria, I think the applicant tried to make a case that their property really was, in some senses, improperly zoned, that it does have sort of unique characteristics, in particular with its limited access to the waterfront. But again, I don't think that they demonstrably indicated that for what they're proposing here, that represents enough of a hardship to say that their property is unique to others in this district. It probably has more waterfront than some of the other properties that could have been attempted to be similarly developed. So with that, I think it fails.
Okay. Does the second have anything to add?
I would agree with what Mr. Rayom has said. Like he's pointed out before, if the applicant applied for a single-family home, even though that would also be a change of use, he would have, I don't think precedent's the word, because there are other single-family homes in that little cutout of waterfront district. That being said, change of use is, like Ms. Margerson said, it's effectively rezoning the property, and this board should not be in that business. That's the planning board.
Well, technically, city council.
Well, technically the city council, correct, but
Ultimately.
We can.
On advice of the planning board.
yeah.
Is there any further discussion? No? Okay. Then a yes vote is to deny the petition. Just want to make sure we Mr. Mantle.
Look at him when you say these
No,
things.
because I start with you.
Okay. Yes.
Okay, Mr. McDonald,
Yes.
Ms. Margerson, Yes.
He's not Miss Murchison.
I got accused of staring, Ms. Murchison. Mr. Maxim,
I've been convinced, yes.
Mr. Rayam,
Yes.
and the chair votes yes. And so the petition is denied. So, the next petition for this,
Okay, no, go ahead.
would someone like a break? No? Okay, how about, I'm sorry, how about if we take a very quick 5 to 7 minute break?
Yeah.
Thank you.
wait.
Been a rough night.
I was counting on being recused for 6:35, and I was going to have my break then. But
Okay, well-
since that never happened, now I.
There you go.
It's okay, it'll be
that
good to just get
urgency
up
to-
for a minute.
This machine has been messed up.
Okay, we're back.
Back.
And the next item of business is item D. The request of the Griffin Family Corporation owners and Lovewell Veterinary Services LLC applicant for property located at 738 Islington Street, Unit 1B, previously advertised as 800 Islington, Unit 1B. Whereas relief is needed to allow a veterinary clinic which requires the following. 1. Special exception from Section 10.440, use number 7.50, to allow veterinary clinic where the use is permitted by special exception. Said property is located on Assessor Map 155, Lot 13, previously advertised as Assessor Map 154, Lot 1, and lies within the Character District 4-W District, LU 23-8. Is there anyone to speak to this?
Thank you, Madam Chairman, members of the board. I'm Tim Phoenix from Hopeful Phoenix, Gormley and Roberts in Portsmouth. I think this one will be simpler and quicker for you folks to review and consider than the last couple, particularly since, and I might mention that Attorney Bozen and his clients will be happy if I can get through this quickly. Last May or so, we were before this board. Oh, by the way, Nicole Justo is with me. She is the owner and operator of Lovewell Veterinary Clinic. So about 8-9 months ago, we were before this board with an identical request for a different location. And that location was about a stone's throw away on the other side of the CVS. And we got approval for this clinic for the with a special exception, but then she wasn't able to work out the lease arrangements. So she didn't take that property. She's now taking this property, and you all know it as the Portsmouth Vacuum Cleaner Repair Company next to the laundromat and, to me, the liquor store on the other end. So Nicole submitted this, and I was going to be here anyway, so I offered to present it for her, and she accepted. She's provided a plan showing the location. She's provided a parking analysis showing that there's plenty of parking. She's provided photographs of the exterior and interior, both front and rear exterior. And the point here is, outside of this office location, nothing is changing. Parking is not changing. Water is not changing. There's plenty of parking for all of the uses that are on the site. So with that, I'll turn to the special exception requirements, which is standards provided by this ordinance. This is 10.232.21, standards as provided by this ordinance for the particular use permitted by special exception. So there's one doctor, which is Nicole. It will serve primarily dogs and cats, household pets. They're not doing any grooming. They're not doing any kennel services. It's going to operate from 8 a.m. to 6 p.m. No training, grooming, or sale of animals. It's just veterinary care. The business is permitted in the ordinance with a special exception. And as I said, no exterior additions or changes. Section 10.232.22 is there's no hazard to the public or adjacent property on account of potential fire, explosion, or release of chemicals. Obviously, there will not be from a small pet animal veterinary practices. 10.232.23, no detriment to property values in the vicinity or change in the essential characteristics of any area, including residential neighborhoods or business and industrial districts, on account of the location or scale of buildings and other structures, parking areas, access ways, odor, smoke, gas, dust, or other pollutant, noise, glare, heat, vibration, or unsightly outdoor storage of equipment, vehicles, or other material. Nothing will be stored outdoors. There's a rear loading area for deliveries. Entrance of the families with their pets will be through the front. It's not going to negatively affect any of those requirements. And thus, it's not near any residences, so no property values are going to be diminished. 10.232.24, no creation of a traffic safety hazard or a substantial increase in the level of traffic congestion in the vicinity. As I mentioned, there's plenty of parking on that site. We call it well, those who have been around a while call it the Pick and Play Plaza, but I think it's known as 800 Islington Street Plaza. So there's not going to be a traffic safety because there's plenty of parking. It's a business use where there was a business use. 10.232.25, no excessive demand on municipal services, including water, sewer, waste disposal, police, and fire protection. I think it's obvious from the nature of the business that that's not going to be a problem. 10.232.26, no significant increase of stormwater runoff onto adjacent property or streets. There will be no change in stormwater because we're not changing anything on the exterior. So that's it. It's pretty straightforward. As I said, you approved a very similar, identical application in a nearby location 6 or 8 months ago. So we ask that you unanimously, hopefully, approve this special exception request.
Thank you. Are there any questions for the applicant? Mr. Mayor.
Yes, thank you, Madam Chair. First of all, just to comment, I'm hoping that looking at the pictures that you provided, which are on pages 234 through 237 of our packet, I'm hoping that the Portsmouth Vacuum Company did a better job cleaning up after themselves when they turned the property over to you than is demonstrated in those photos. But that said, my only real concern with the application, and it's mentioned twice in the written portion of the application, and you sort of touched on it as well, is that is intended to be a small animal veterinary clinic. And unfortunately, our zoning ordinance, when it talks about veterinary clinics, looking at the definition, it really doesn't limit them necessarily to small animals. And I do think this particular location, because of the size of the unit, because of some of the potential complications of having to cross a road, sort of a roadway area to get there, the nature of the parking and whatnot, understand that that's what your client is looking to try and do. My concern is obviously this runs with the land and could become something that somebody could use in the future. If there was a stipulation put in, something to the effect of that it was granted for the care of dogs, cats, and similar small animals, would that be something that would be acceptable to your client?
Yes, she's nodding yes, it would. So, no pigs, horses, cows, nothing like that.
Okay.
I'd like to leave it loose enough that she could have a guinea pig or a rabbit or something. Sure. But basically, the largest animal would be dogs, right? Most likely.
Yeah. Okay.
And as to your comment, I asked you the same question. How you see these pictures is how they left it.
Yeah.
It doesn't look that way anymore.
All right.
It is ironic. Are there any other questions? Okay, thank you.
Thanks.
Unless you have more for us.
Nope.
We're good. Okay. Is there anyone in the public who would like to speak in favor of this application? Is there anyone in the public who would like to speak against this application? Is there anyone in the public who would like to speak to, for, or against this application? Public hearing is closed. Yes, Mr. Mayor.
Madam Chair, I would move that we approve the request for a special exception with the stipulation that it be limited to dogs, cats, and other small animals.
Is there a second?
Second.
Thank you, Mr. Mantle.
Okay, thank you. So I'll go through, and my concern with the small animals, just simply, I do think this kind of space, I think dogs and cats getting in there, and the odd guinea pig and whatnot, is probably fine. I just am fearful, again, this runs with the land. The way that this is all set up and the size of this particular unit, the sort of the congested nature of that parking lot in that area, and with the fact that there is quite a bit of traffic in that particular end associated with the laundromat that is there. Even on a busy day, pick and pay parking starts to wander into that area. You also have the restaurant that has its cadre of folks that are taking up parking. I think there's plenty of parking overall, but I just think some of the complications of it, if we weren't limiting it to these small animals, could in fact become a problem. So with that, this is allowed by special exception, so it meets the 10.232.21 criteria. 10.232.22, no hazard to the public or adjacent property on account of the potential for fire, explosion, or release of toxic materials. Again, a veterinary practice is very limited in those areas. It's certainly not like a filling station, gas station, or anything along those lines. If there are any toxic materials whatsoever, they're extremely minimal in nature. The types of equipment that are used have a very low potential for fire and would be well within what would be expected for this type of development. 10.233.23, no detriment to property values in the vicinity or change in the essential characteristics of the area, including residential neighborhoods, business. This is where I do think that the concern that I have talks to account of location or scale of buildings or other structures, parking areas, access ways. I do think there is a concern about having a broad different types of animals and larger animals being delivered on a a larger trailer or something and getting a horse out of there. Again, not what the applicant is asking for, but this runs with the land, so I think it's important that we are careful on that. There are, access ways, odor, smoke, gas, dust, or other pollutants, noise, glare, heat, vibration, unsightly outdoor storage of equipment, vehicles, or other materials none of those things would be expected with a veterinary practice. 10.233.24, no creation of a traffic safety hazard or substantial increase in the level of traffic congestion in the vicinity. As the applicant has indicated, there are additional number of parking spots because especially with the small size of this unit is very minimal compared to the other uses that are around it. And while there is some challenges to the parking in that area, the applicant is really not adding significantly in any way to those concerns and therefore meets that criteria. 10.233.25, no excessive demand on municipal services, including but not limited to water, sewer, waste disposal, police, and fire protection in schools. Again, this proposed use for a veterinary clinic, especially one for small animals, would not in any way, shape, or manner create any significant impact on those services. And then lastly, no significant increase in stormwater runoff onto adjacent property or streets. What is being asked for here is a use variance. There is no change to the existing property, and the existing property performs satisfactorily in those areas, and therefore I recommend approval with the stipulation as noted regarding dogs, cats, and small animals.
Do you have anything to add?
I agree with what Mr. Room has stated. I'm looking forward to you having a large supply of Irish Wolfhounds and Newfoundlands as your clients.
As long as they can come in a car, it's okay. So,
Yeah.
Is there further discussion? Okay. The motion on the floor is to approve the special exception. Mr. Mantle?
Yes.
Mr. McDonald?
Yes.
Ms. Margison?
Yes.
Mr. Mattson? There are so many M's. Do you know how many M's there are, Mr. Mattson? And Mr. Graham?
Yes.
Yes, and the chair votes yes.
Thank you very
You're
much.
approved. The next item on the agenda is item E. The request of Aviation Avenue Group LLC applicant and Pease Development Authority owners for property located at 80 Rochester Avenue, whereas relief is needed for the construction of an advanced manufacturing facility which requires the following. 1. Variance from Article 304.03E to allow a 28-foot rear yard where 50 feet is required. Said property is located on Assessor Map 308, Lot 1, and lies within the Pease Industrial District. Is there anyone to speak to this?
Good evening, Madam Chair, members of the board. Ms. Casella, I'm Attorney John Boson. I represent the applicant. And we are proposing to build a manufacturing facility at 100 New Hampshire Avenue, which is located in the Pease Development Authority Industrial Zone. With me tonight from Aviation Avenue Group I'd like to introduce Evan Tormey, John Stebbins, and also Neil Hansen from Ty and Bond. Here to answer any questions you may have. This property is currently a vacant 11.4 acre parcel that will be redeveloped for an advanced manufacturing facility that will feature robotized manufacturing, and that will be utilized to create highly skilled and highly compensated jobs. As you may recall, this project did receive a variance from this board back on November 15th, at the November 15th meeting, from Article 3.04.03C of the Pease Development Authority zoning ordinance to allow a 51-foot front yard setback where 70 feet is required. After the variance was obtained, the applicant received more detailed plans for the manufacturing facility and became aware of a setback problem due to the location of the existing Rochester Avenue right-of-way and its utilities. in order to keep the existing Rochester Avenue right-of-way in its current location and maintain the utilities in the right-of-way while preserving the proposed building's structural column layout, which is ideal for advanced manufacturing, we now are requesting a rear yard setback from Article 304.03C of the Peace Development Authority zoning ordinance to allow a rear yard setback of approximately 28.4 feet where 50 feet is required. The applicant did meet with the Peace Development Authority on January 19th and did receive a recommendation for this variance. You'll find that material in your packet. The proposal otherwise meets all requirements of the zoning ordinance. So with that background, I'd like to go through the 5-step criteria necessary to grant this particular variance. First, no adverse effect or diminution in values of surrounding properties would be suffered. And granting the variance would not in any way diminish the value of surrounding properties. All of the surrounding properties are industrial, commercial, and have similar setbacks to what the applicant is proposing. 2, granting the variance would be a benefit to the public interest. Granting the requested variance would not substantially alter the characteristics of the neighborhood, nor would it threaten the health, safety, or welfare of the public. This property lies in the industrial zone where manufacturing is permitted and is consistent with other uses in the zone. So granting the variance would not be contrary to the spirit and intent of the ordinance, nor would it be detrimental to the public welfare. Next, denying the variance would result in unnecessary hardship. The special conditions of this property are the fact that the property is burdened by wetlands that would be compromised if the building were pushed further back to accommodate the setbacks. Also, the right-of-way here is 80 feet wide, which is approximately 20 feet wider than a typical right-of-way. So the combination of these two factors are unique and create special conditions which prevent the property from being reasonably used in strict conformance with the ordinance. Fourth, granting the variance would be substantial justice. So granting the variance would result in substantial justice being done. The hardship upon the applicant were the variance to be denied is not outweighed by some benefit to the general public in denying the variance. And lastly, the proposed use would not be contrary to the spirit of the zoning rule. The property sits in the industrial zone where manufacturing is permitted and is consistent with other uses in the zone. So the Peace Development Authority is supportive of this project. So requesting the variance would not be contrary to the spirit and intent of the ordinance. I think we do meet all the 5 criteria. I would respectfully request approval of the variance as advertised. Myself and my team are happy to answer any questions you may have. Thank you.
Does anybody have any questions? Yes, Mr. Reed.
Yes, thank you, Madam Chair. Couple questions. One is, you talk in here about, under 3, Section 3, talking about the denial of the variance will result in unnecessary hardship to the person seeking it. The second paragraph, the special conditions of this property are the fact the property is burdened with wetlands that could be compromised if the building were pushed back further to accommodate the setbacks. So I guess I'm a little confused about what's front and back, and I know that there's kind of this question about, is it on Rochester, is it on New Hampshire?
Yeah.
But I'm also struggling to find out where those wetlands are and why those wetlands are affecting the positioning of the building. So if you could explain that a little further.
Yeah, maybe it would be helpful if we could step the map up. And I might have
Yeah,
Neil-
page 253
Neil
on our package, I think.
So the issue has to do with the, there's actually a buffer that goes into the road, and I may need Neil to better explain that, but. In that area, that's where there's a buffer that's impacted, so if we push that building back, we're gonna be in the buffer.
Okay. Yeah, I guess I mean, it looks like a parking lot. I'm not quite sure where the wetlands are actually located there. There's a little, what looks like a little piece,
Yeah.
maybe, up in the corner.
Yeah, so Neil Hansen with Tyne Bond. So the wetlands are on the opposite side of the street, right where John's pointing there. And a previous concept version of this plan had a longer and narrower building, and that pushed the parking closer to the right-of-way line on our side of the property, which was getting near that wetland buffer, and also required some reconfiguration of the street when we were shifting the right-of-way initially. So going back to that, leaving the road where it is, we avoid having to do any of that work that's in or near that wetland. Wetland buffer. We were never near the wetland itself.
Okay, so your argument is to fully meet it, you would need, to get the building that you want and to fully meet the setback, you would need to move the road, which would impact the wetlands. Is that what you're arguing?
In part, yes.
Okay.
And the road itself is wider than a typical roadway, and that's the other part of the
Right.
the hardship issue.
Yeah, I mean, I saw that argument. It is 20 feet wider. Okay, you're asking for 22 feet. A 20-foot width would give you 10 of those 22 feet, but, okay. I'm trying to understand, you talk about all surrounding properties are industrial, commercial in nature and have similar setbacks. Do you have any examples that help reinforce that point?
I think the property right across the street has a similar setback. Would be
Yeah, because my quick check of Google Maps, I mean, at least, yeah. I was, okay. Across the street. So you're talking the Seacoast Media Group?
Seacoast Media Group.
Okay. Which is sort of their front setback
Right.
relative to New Hampshire Avenue.
Yeah.
Okay. And then you talk about this desire for this 2-to-1 ratio, and understand that looking at your building, it looks like it's a 2.1 to 1 ratio on length versus width. I tried to do some Google searching and find out where this magical golden ratio comes up for advanced manufacturing and why that's so important. I could not find anything. I don't know if you have any further explanation as to why, again, your building needs to have these proportions and why your plan is, necessary to fulfill the desire for the advanced manufacturing plant.
Well, I may have to have the applicant speak directly to that, but the building that they're proposing to build for this advanced robotized manufacturing has a certain column width and depth that they don't want to alter if they can help it. So that's driving the size of the building.
Well, it's driving the proportions of the building. I guess that's my other question is you could still meet the 2-to-1 ratio with a smaller structure and continue to abide by the setbacks. Is there something in particular with the size of this structure that is important to the usability or rentability of this
Well, I
particular
think
application?
As was discussed at the Peace Development Authority, it was these 50 by 50 foot bays and the 2-to-1 length to width ratio that was desirable. The concern being that a narrower building would not suit that purpose.
Right. Yeah, my argument is if you need to keep the ratio, you could make the building overall smaller in dimensions unless there's something that's driving the total square footage of the facility.
I think it's just
trying to understand.
Yeah, it's just the overall desire for this to function as an advanced manufacturing facility, which is something a little different to this area that we believe will drive, highly skilled and highly skilled jobs and higher paid employees. So there needs to be a certain size and size of the base, size of the building, length to width ratio that is most desirable. Could it be smaller? Don't know. But the building that this applicant is proposing has to meet this type of ratio for it to be, desirable project.
Okay. And last question, if I may, Madam Chair.
Yes, please.
Just to be clear, this is an additional variance beyond what was previously asked for and approved. You still need the front setback.
That's correct.
variance as
We
well.
still need the front. It wasn't until these more detailed plans became available that we realized we needed to come back for.
Okay.
We
Thank you.
recognize it's not desirable to do this in two parts.
Okay. Thank you.
Any other questions? Okay, thank you.
Thank you.
We're good. Okay, is there anyone to speak to, for, or against this petition? Is there anyone to speak in favor of this petition? Is there anyone to speak in opposition to the petition? Okay. If not, the public hearing is closed. And what would we like to do? Yes.
I'll make a motion to recommend approval. And I appreciate the questions and answers that just occurred by Board Member Reum and the applicant.
Is there a second before Ms.?
I'll second.
Okay.
Okay. So to meet the 5 criteria, number 1, no adverse effect of or diminution of values of surrounding properties would be suffered. This is on Ps. The other surrounding properties are industrial, commercial with similar setbacks. The number 2, granting the variance would be of benefit to the public interest. This is currently a vacant lot that will be developed for an advanced manufacturing facility that'll bring productive and good-paying jobs. Number 3, denial of the variance would result in unnecessary hardship to the person seeking it. This went through technical advisory committee, and because of the wetlands buffer and the large right-of-way and the utilities on the street, this would result in pushing it back, and hence the required variance. Number 4, granting the variance would do substantial justice. The hardship of denial is not outweighed by the benefit to the public. Number 5, the proposed use would not be contrary to the spirit of this zoning rule. This parcel is in the industrial zone, and the manufacturing use is permitted.
Thank you. Anything to
I
add?
have nothing to add.
Okay.
Very good, Jeffrey.
Is there any further discussion? Yes, Mr. Mayor.
Thank you. I will support the motion, although I found the applicant's argument wanting in several areas. I think some of the logic was a bit convoluted, and some of it was not really being supported by the facts of the case. What I do think are facts is that in terms of setback relative to Rochester Avenue, the National Visa Center, which is just a little further down, I think, I didn't go out and measure it, but looks like it has probably a similar setback. I think they're also taking advantage of the fact that there's another building that is directly across the street, across Rochester Avenue, that is really sort of pushed up against Aviation Avenue. And so with that, I think that there is some clear space there that they won't be overly imposing for the industrial area. So with that, I would support the act, what is being asked for.
Okay. Any other discussions? Okay, I'm going to start over here. Mr. Mattson?
Yes.
Mr. Rayam?
Yes.
Ms. Marterson? Yes. Mr. McDonald?
Yes.
And Mr. Mano?
Yes.
And the chair votes yes, so you're good.
She's got the names right, though. When she looked, she got the right name.
It is a lot of M's, though,
There are a lot of M's.
and N's.
You can use my maiden name if you want.
I could call you by first names, you know.
Yeah.
Doesn't anybody do that on boards? I'm sorry.
Sorry, that's for amusing up here.
Well, I mean, learn a little of the past chairman's attributes.
Yeah, state
No.
One more.
Oh, those poor people. Okay. The request of William Camarda, is that how you say? Owner for property located at 809 State Street, whereas relief is needed to extend the existing deck, which requires the following. 1, variances from section 10.521 to allow A, a 10-foot rear yard where 200 is required, and B, 46% building coverage where 35 is the maximum. A variance from section 10.321 to allow a nonconforming building or structure to be extended, reconstructed, or enlarged without conforming to the requirements of the ordinance. Said property is located on Assessor Map 145, Lot 11, and lies within the General Residence C District, LU-23-6. Is there anyone to speak to this? We thank you for your patience.
We love a happy applicant.
I was thinking at the end of this, maybe I'd put a valet parking lot in the backyard, but I'll just stick with the deck.
It's a part of the CUP, you know, that's what's important.
Sorry, I got punchy this late at night. Cool. So my fiance, she's mortified. My fiance, Bennett, and I, we moved into 809 State Street end of 2021. And there's an existing deck off the side of our house. And it's a little bit shallow, and so we'd like to extend it a bit. And so the variances we're looking for are on an existing setback where the deck is 10 feet away from the property line. I think like the stairs actually go down, and where we want to extend the deck into the yard is 10 feet away from that back property line. And then the other variance we're looking for is our lot coverage. So extending the deck by 4 feet 2 inches would actually increase our coverage from 42.2% to 44.7%. Thanks to Bennett for the math there. I was struggling a lot. And I just want to run you through the criteria for this variance and how we were thinking about it. It won't be contrary to the public interest. So the deck is pre-existing, so the functionality and how we're going to use it is mostly the same. It's just really shallow, and we want to have a family there, and I don't know, it'd be nice to have a couple of kids be able to run around out there if possible. And then two of the property lines where there's, under 20 feet of clearance. One is the house to our left, which they would never see the deck. And then the other is where there's already 10 feet of existing clearance. The spirit of the ordinance will be observed. The existing deck, or the extension of the existing deck, will only increase our lot coverage by 2.5%. It won't obstruct anyone's views. It won't impact any of the other setbacks, and we're not encroaching on our neighbors in any meaningful way. The deck will be going into our yard and taking up some of that space. I think that also covers 10.233.23, substantial justice will be done. And then the values of the surrounding properties will not be diminished, 0.24. We're one of the few single-family homes in the neighborhood, so although I'm not a licensed realtor, I hope that increasing the value of our property will help everyone else around us, including a lot of those multifamily properties. And enforcement of the provisions would result in hardship if we didn't have the extra 4 feet 2 inches. I mean, it wouldn't kill us. I think we would manage just fine. But at the end of the day, it does impact the functionality and how we plan to use the space and how we want to grow into the space. So for that reason, and impact the value of the property itself. So for that reason, I think it would provide hardship, but not the end of the world. But we would really much appreciate it. That's my application. I don't have a lot of the legal jargon as some of the other folks earlier, but
You did very well.
did my
Are there
best.
any questions? Go ahead, Mr. Mantle.
What's the current width of the deck?
The current width of the deck, I think it's, man, I should have brought the plan in front of me. Oh, there it is. It's like, yes.
I assume your fiance is in the pink shirt.
Yes.
Okay.
Yeah.
Just identifying people in the photos.
Yeah, that's her. So it is 20.5 feet long. Yeah.
What's the width from the house?
The width of it is 8 feet 4 inches deep, or wide. So that's the width. Yeah, the length or the width is 20.5 feet long, and then it's 8.5 or 8 feet 4 inches deep.
From the house?
Yep.
And you want to make it 12?
Yep.
Okay. My only question. Thank you.
I'm looking at other pictures throughout tonight's, and I'm very embarrassed by mine.
It's fine. We get it. Mr. Matt, I'm sorry. Mr. Van was first. Okay.
Okay, thank you, Madam Chair. First of all, it is now a matter of public record that you said that you talked about having 2 children, so I just want to make sure that your fiance took note of that.
But she's the one with the math skills.
One of my
She's all the
points is,
skills.
going back to the math, city staff, and I just want to validate with city staff, you did redo a calculation, and in fact, the open space requirement is 46%, is that, or the, I'm sorry, the coverage is 46%?
Are you talking about the discrepancy between?
Yes.
So originally, the applicant didn't include the shed. And so the table is correct in your memo.
Okay. So the requested variance is 46%, an increase of 4% over the existing 42, is correct?
Yes.
Okay, just wanted to make absolutely
Fiancé
certain.
agrees.
That's correct. Yeah, so looking at page 337 that you have up here, it did take me a little while to try and interpret this, but I did finally kind of figure out what was going on looking in combination with the pictures. What is the basis for the 10-foot clearance? What are you measuring to? What are you using as
Yeah.
the basis for your property line?
Yep, so on the far right side of the deck, so on the back side of the property, right, see where the shed is? That is the property line, and the existing owners have the deck abut up to that fence, but I did the clearance from where we want to extend it is to the left of the stairs, and so from that stair railing on the left side, where we want to extend it, is exactly 10 feet from the back property line.
So you're presuming that the fence is the property line?
Yeah.
Is that correct? Okay. And then, so in the staff memo, it says that we believe the existing setback from the back property line is 2 feet for all the structures. But you're kind of implying that maybe, is your house really 2 feet set back and your current deck 2 feet back from that fence line that you're presuming is your property line?
As far as I know.
Okay. And you're positive about that 10-foot dimension because that is critical on our approval. It will be 10 feet. So I just want to make sure that you're confident that your measurement to at least that fence line is in fact 10 feet.
I measured it, so it could be a few inches off, but I am almost positive.
Okay.
Can your fiance measure it?
Honestly, yeah. She probably should.
Okay.
And I guess, yeah, that was going off of if the fence was the exact property line.
Okay. I mean, in many cases, we don't require a survey, but sometimes when you start digging for, this is really not truly a structural foundation, but you will probably be putting in posts and whatnot in here. You're going to be digging, putting down some sonotubes or something.
Yes.
I'd imagine for your posts. So just, we want to make sure that when you construct it, it is going to be something that if it was being validated by city officials, that they would be confident that you're meeting the spirit of what we're approving here today, should we approve it. Thank you.
Mr. Metz?
Yep. I have two questions. The first is, are you planning on changing the stairs?
No.
Okay. And then second, in this image, you can see the green pipe coming out of the ground. I don't know if you know what that is, or maybe if it's a sewer clean out, how that, covering that, what the effect would be.
I actually don't know what that is. So I'm not sure what covering it would or wouldn't do. That's something I can also ask my contractor and our plumbers too.
Okay. But presumably you'd be able to remove the lattice work to essentially as a crawl space under there?
Yep.
Okay.
Any other questions? Anything else you would like to say to us?
No, I think that covers it. Really appreciate it. My only question is, how would I find out my exact lot line, where that actually starts and what that clearance is? Is it exactly 10 feet? Did I mess up my measurement? I just don't want to cause pain for anyone in this room down the line if you're like, hey, it's actually 9 foot 9 inches and I messed up.
Yeah, I don't know. Staff wants to speak to that.
Yeah.
My usual recommendation is to go around the edge of what you believe to be your property line and see if you can find any boundary markers. You may also have access to a survey that was done in the past. Sometimes you get those in your when you're buying your property. You can also check our records and see if we have any boundary or survey data on file, as well as at the Registry of Deeds.
Okay.
And I don't know if your deed contains like an old deed registration with a lot of fences and running westerly, or if it's based on modern survey.
Okay.
But that's another area.
Or it says when the fences lie, which is not unheard of in our city as well.
Yeah.
I mean, we wouldn't do an as-built survey for a fence, for a deck, would we?
Usually not.
That's a question I would have to check with inspections on, because that's more their purview.
Yeah, I guess I would just add that, just so it's not a two-part process, if we approve the 10-foot setback, if you were to get a survey in the future or to measure between the two rear property corners, if there's stakes there or property rods, you could, instead of just making it right up to the stairs, you could make sure that whatever you do is still 10 feet from the property line. If, say, the edge of the stairs was 9'9", you would just lose those 3 inches to make sure you were still conforming.
And widen maybe the stairs a little bit to that point.
I don't know if you would
It
be
would
able
probably
to
be narrow
change
if
the
it-
stairs,
yeah.
because those are within the non-conforming part.
If it's further than 10 feet, then you're good. If
Okay.
it's less than 10 feet,
Yes,
the
so the-
suggestion is to narrow the steps, because that's the point that's sticking out.
Yeah, the only issue would be if the fence were actually beyond your property line, or if you incorrectly measured.
I believe it's okay for us to go ahead, though, tonight with your best, I'm not going to call it a guess, but the best information that you have. And we can put a note in there that allows a little wiggle room for your,
Got it.
yes.
Thank you.
Okay, and it's done. You're not the only one who isn't exactly sure.
I mean, sometimes we do, what's the equitable waiver of dimensional?
Yeah.
That's another action
Yeah,
for this
so
board.
correction for a thing, so, anyway.
Cool, thank you.
Okay, if you are done, I will open it to the public. You may sit.
Okay. Oh.
Is there anyone who would like to speak in favor of this petition? No? Is there anyone who would like to speak in opposition to the petition? Is there anyone who'd like to speak to, for, or against the petition? Okay. Public hearing is closed. What would we like to do? Yes, Mr. Miller.
I make a motion to approve the application as presented.
Is there a second?
I'll second.
Thank you, Mr. Mattson. Go ahead.
This is the kind of application we all like. It's a minimal request for a deck. The 10 feet doesn't bother me as much. The building coverage does a little bit, but not for this area of town, simply because I'd be surprised if anybody on State Street is at 35% or below. That being said, to the 5 criteria, granting the variance would not be contrary to the public interests. As you can see by all those people speaking against it, I don't think the public is concerned. Granting the variance would observe the spirit of the ordinance. Yes, it would. New family, outside space is important, and given how young the kids will be, having them close to the inside is a lot more than hanging out in the yard, where they can get out on State Street. Granting the variance would do substantial justice. I believe it would. Granting the variance would not diminish the values of the surrounding properties. I don't think it would at all. If anything, it would enhance the value of this property and likewise the surrounding properties. Literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. The property has special conditions to distinguish it from the other properties in the area. Owing to these special conditions, a fair and substantial relationship does not exist between the general public purposes of the ordinance and specific application of the provision to the property, and the proposed use is a reasonable one, which I do agree with. Not granting it would present a hardship. I believe that this is the more dense area of State Street. And for those reasons, I made the motion to approve.
Anything to add?
Yes, I'll just add, first, this deck portion will be less non-conforming than the existing house structure and that portion of the stairs that's there. And the small increase of building coverage from 42, the 4% increase from 42 to 46 is not a very big ask. And also, this is an interesting situation where normally a deck addition becomes closer to the rear, whereas this is actually going towards the side, more to the inner portion, the central area of their parcel. So for that reason, I'll make the second it.
Thank you.
Okay. Is there any further discussion? I'm going to support the motion also. I think that the applicant is gaining a lot for the 10 feet increase, and yet the coverage is only increasing by 4%. And they're surrounded, they're private, they're not infringing.
Thank you, Madam Chair. Yeah, I'll be supporting the motion as well, and I do think the key factor is that the increase in coverage is really towards the center of the lot. It is not impacting the surrounding neighbors, would not be perceived by anyone going by. So I think that's a key factor in my support of it.
Okay. If there's no further conversation, discussion, then a yes vote is to allow for the deck. Mr. Mannell?
Yes.
Mr. McDonald?
Yes.
Ms. Margerson?
Yes.
Mr. Mattson?
Yes.
Mr. Rayam?
Yes.
And the chair votes yes. So you can get started.
Get started.
Building the deck.
Oh, okay.
Is there a,
But they said make
is there any new business? If not, is there a motion to, any further
Make a motion to
discussion
adjourn?
that anybody wants to? Anything anybody wants to bring up?
Motion to adjourn?
Okay, is there a second?
Second.
All in favor?
Aye.
Aye.